Morning glory and evening grace, America. I'm Hugh Hewitt. Welcome to the program. Hope many of you had a chance to see Vice President Vance on the Salem News Channel earlier or listen to him on the Salem Radio Network or our affiliates. I will talk about that later in the program. But I begin today with Associate Justice of the United States Supreme Court, Justice Amy Coney Barrett, who has a brand new book out, Listening to the Law, which is a fabulous read, and I want to talk to her about that. I had a chance to do so 5 days ago at the Nixon Library in Yorba Linda, so this is round two, so I get to actually finish my question. Justice Barrett, thank you for a second bite at the apple. I have to begin, though, by asking, 2 hours after I was done talking to you, my colleague Charlie was murdered. Your reaction to that and to just generally political discourse in the United States, about which you write a lot in Listening to the Law.
That was horrific. I was at Notre Dame shortly after I left you at the Nixon Library, and the mood on campus was very somber. I mean, for the father of 2 young children and a husband to be murdered in cold blood was a tragedy and certainly sobering for the nation. And I think it is a sign of a culture that has where political discourse is soured beyond control, and something that we need to really pull back. I mean, obviously, I assume that the person who murdered Charlie Kirk was mentally ill, but nonetheless, to create a culture in which political discourse can lead to political violence is unacceptable in the United States.
Justice, you quote your father in the book as saying repeatedly to you and your siblings, control your emotions or they will control you. It's very similar to a message I got repeatedly growing up. Do you think that message is out of style, or do parents have to double down on that message?
I think it's time to double down on that message. That was a message that, as you say, my father repeatedly gave my siblings and I. It's one that I've repeatedly given my own children, that I've put up in various places on index cards around our house to remind them of the message. And I think in political discourse and relating to one another just generally, I think we often let our emotions get out of control, and we're driven by emotion rather than reason. It can take discipline to speak civilly and collegially to people with whom, one disagrees.
You referenced G.K. Chesterton as well, and his brother on page 38 of Listening to the Law. The two argued incessantly but never quarreled. You continued, a good argument involves logic and a search for truth. A quarrel is an effort to tear down your sparring partner. Sparring with intellectual opponents is the way to hear the other side. Shunning others just because they disagree with you is also a recipe for a lonely and ultimately unhappy life. Do you think that people are going to hear that message more clearly now?
I hope so. I mean, I really hope that the assassination of Charlie Kirk is a turning point for us as a society, where we look and see where things have come, the point at which we've come to in the United States. I mean, there's a big difference. I see 2 dangers that Chesterton passage that you just read gets at. One is to silo ourselves so that we don't engage with the other side. That's the opposite of what Charlie Kirk did. He consistently engaged the other side. I think the other message in that passage is that when you do engage the other side, we're engaging ideas, and we're not trying to attack or tear down people. And there's a huge difference between the two. And I think those who fall into attacking people primarily do it verbally and not physically. But too often, I guess, we're now seeing that verbal attacks can spill over into something more sinister.
Justice, now I want to turn to Listening to the Law, and I'm going to come back to the problem of our culture in a moment. But I want to remind our audience that before you joined the Seventh Circuit in 2017, you had spent 15 years teaching at Notre Dame University's law school. Before that, you had clerked on the Supreme Court for Justice Scalia, on the D.C. Circuit for Judge Silberman. You had attended Rhodes College. You'd worked at Miller Cassidy. You spent your whole early life in New Orleans, and now you've been on the Supreme Court for 5 years. Ought presidents to think, you represent something very different on the Supreme Court. A Southerner, though, Louisiana and New Orleans are very different from the rest of the South, and not an Ivy League trained lawyer. I'm very happy to have the President of the United States, and I mentioned to you this on Wednesday, reaching beyond the Ivy Leagues for justices. Do you hope that continues at least intermittently in the years ahead?
I do. People have asked me that, especially as I've been around talking about the book. And it's not that I think people should be chosen from outside an Ivy League school for the sake of doing it, but I think people choose law schools for all kinds of different reasons. To assume that people are unqualified if they choose to apply to schools outside of the Ivy League and choose to attend those schools, I think really distorts and takes people out of the running who make decisions based not solely on prestige, who make decisions based on scholarships and financial aid, to make decisions based on geographic considerations like the locations of their family. Just don't think we have a culture in which every single person is motivated to apply to and then only attend the top ranked law school which they get into. That was not how my own decision process unfolded.
Now, Justice Barrett, the very last justice of the Supreme Court that you mention or quote in listening to the law is the great Potter Stewart, the great pragmatist. And is it incidental, accidental, or intentional that you quoted him at the end? The justice best known for "I know it when I see it," but he also said the docket of the Supreme Court is a fairly reliable mirror of our domestic problems confronting our nation. I agree with that, but were you doing something intentional in pointing at Justice Potter Stewart, who was a long time sort of center right justice?
No, and Hugh, I confess that when I quoted that passage, it didn't occur to me that I might be sending a subtle message. I quoted it because of the quote itself. I think a lot of people think that the court somehow sets its own agenda or goes out and finds, the most controversial cases to decide. But I think Justice Stewart was absolutely right. If you look at the court, you see back a reflection of what's happening in the country.
Listening to the law is almost Bartlett's when it comes to quotations about the Constitution and the Supreme Court. But, however, one that does not include either is John Adams on Ben Franklin. And John Adams was very disapproving of Ben Franklin's style of life. Adams said, "As far as fate shall compel me to sit with him in public affairs, I shall treat him with decency and perfect impartiality." Then you add, "There's no reason to treat colleagues any other way." I see that breaking down. I try and abide by that myself, but do you see it breaking down?
I do see that breaking down, and I think it goes back to what you talked about in the beginning, which is learning how to debate ideas and attack ideas, not people. I guess I think the idea or the notion that you can't like and work with or treat civilly, as John Adams with Ben Franklin, people with whom you disagree or even that you dislike, is just foreign to the way we ought to be conducting public affairs and personal ones. I mean, it kind of is back to that control your emotions or they'll control you. I mean, frankly, in every walk of life, you're not going to like everybody, but you can't, you've got to control your emotions and you just can't treat people consistent with the way you sometimes might feel about them.
Well said. Let me go now to some nitty gritty of the law. I brought this up at the Nixon Library, concurring opinions. We covered this a bit. On page 39, you explain that you sometimes write concurrences, quote, to identify areas of law that could benefit from development by advocates and scholars. And you footnoted that to Fulton versus City of Philadelphia. One of our regular listeners is now retired Archbishop of Philadelphia, Chaput, who brought that case. And in that concurrence, you invited scholars to opine on what could replace the test of employment division versus Smith, which is a little too geeky for the audience. But then you surprised me at the library by saying no one had taken up the challenge. Does that happen often? Do scholars avoid the stuff that the justices could profit from?
I'm waiting, Hugh, after I said that at the Nixon Library, I'm waiting for a deluge of law review reprints from scholars who say, I certainly have taken you up on that challenge. I do over every summer try to read scholarship to see what has come up in the interim. I haven't had time this particular summer to do that with respect to Fulton, so maybe I missed something. I think people respond with scholarship to their interests. It could be that people have not been interested in that case. And I haven't had another case present that question squarely, so I haven't had reason to dive in. But I mean, I think if the court or an individual justice on the court highlights a particular area as one that would be useful to get more scholarship on. I would think that would be a motivation. It would have been to me as a law professor.
Yeah, I would have thought Judge McConnell would have weighed in, but then again, he took over the job of Chief Justice of the Meta Supreme Court, so maybe he hadn't had the time. But I am surprised, and I hope just by bringing it up here, the 9,000 full-time law professors in the United States give an ear to that because it's a difficult issue. It's a very an important one. I do want to repeat about Abigail Adams because I found it fascinating in the book that her portrait, and you confirmed it on Wednesday, hangs in your office. Would you tell the audience why they should read, get the full story, and listening to the law, but why?
Sure. In brief, the Constitution is obviously a large part of what I do. And because I interpret the Constitution as an originalist, I look back to the founding era a lot. And I wanted some inspiration, some reminder of that in my office. But I also wanted it to come from someone whose life looked at least a little bit like mine, despite the fact of living in a very different age. And there were no women at the Constitutional Convention or any of the state ratifying conventions. So Abigail Adams is about the closest that we can come. She was very involved in advising her husband, John, about public affairs. She was very attentive to all the affairs of the time. Yet she raised a large family, managed her family's finances, all while participating to the greatest degree that she could at the time in the formation of the country. So I have her up above the mantle in my office. It would make you dizzy if I picked up the iPad I'm using right now to flip it around so you could see that picture, but I reprinted in the book just to remind me of Abigail and her participation in the founding of the Republic, and just to inspire me about the promise of America, because now, of course, I can do what she could not, serve
Now,
simultaneously on the Supreme Court and as a mother.
oh, I'm glad you added that as a mother. Anyone who has not watched the HBO series Adams from, I gosh, 15 years ago, I would recommend because of its portrayal not only of John Adams, but of Abigail Adams. It's fabulous. Justice Barrett, we also talked about the founding era. Now, the Second Continental Congress passed the Declaration of Independence, and there are parts of it, and you told me why it does not count for you in interpreting originalist intent. But I went back after we talked and I read it. And for example, in the Bill of Particulars, the Second Continental Congress wrote, King George has erected a multitude of new offices and sent hither swarms of officers to harass our people, eat out their substance. That seemed to me to be one of the examples where the Declaration might, figure into Loper Bright or the Major Questions Doctrine or something like that. Would you explain to people again, as you did at the library so eloquently, why you do not consider the Declaration as among the founder materials relevant to the interpretation of the Constitution?
Well, maybe I didn't explain clearly what I meant by that. I don't consider the Declaration, I understand some people to make the argument that the Declaration itself is a source of law. And I don't consider it to be a source of law because the Declaration of Independence wasn't ratified as law as our Constitution was. But I do think when you look at the founding era and you look at the array of materials, I mean, certainly I would look at the Declaration of Independence, much like I would read Blackstone's commentaries. I mean, it was part of the political culture in which those who adopted our Constitution were steeped.
Oh, I misunderstood you then, because that is exactly what I thought that's what you were going to say, and I didn't hear it, but that's on me. I want to go to the very interesting part of listening to the law, where you add your voice to that of many scholars that the Sedition Act of John Adams' era was unconstitutional. Good on you. What do you think about Thomas Jefferson's acquisition of the Louisiana Territory?
That's an interesting point. Thomas Jefferson himself thought his acquisition of Louisiana Territory was beyond his power. He thought it might be unconstitutional, but he did it anyway, which is an interesting addendum. I mean, I think at this point in the day, and as someone who was born in Louisiana, I'm certainly not advocating for an argument that the Louisiana Territory is not validly part of the United States. I think that's been settled by time, even if Thomas Jefferson was right to doubt his own constitutional authority.
Are there other parts of the old law that need to be clarified, such as your comment? The court officially repudiated Korematsu, thank goodness, and for the benefit of the lay people out there, the decision of the court that the internment of Japanese American citizens was constitutional at the time has been repudiated by the Supreme Court subsequently. Is there any other cleanup on aisle 3, the Kmart green light thing? Does the Supreme Court need to do that?
You mean overrule a precedent or clarify that some past act actually was unconstitutional?
Correct.
So there are certainly cases in my own personal capacity or that I might have thought as a law professor were wrongly decided and then I wish the court would correct. But just now, in my capacity as a justice, I can't identify those cases with the same freedom that I could before, because I have to stay my hand in the event that any of those questions actually came before the court. Because
yeah, of course you do. Yeah.
Yeah. I mean, the court, with respect to the sedition acts, the court has said, the court itself has said that those were unconstitutional, in New York Times versus Sullivan. The court acknowledged that, and I think that's pretty widely regarded as unconstitutional. So it's not a controversial question likely to come up before us. So I try to be pretty careful in the book to hew towards describing doctrines that opinions that the court itself has already expressed.
You also note in the book that the Roberts Court, of which you are a part, that's a direct quote, averages about one overruling a precedent a term, which is below the historical average for any of the other courts. And with that in mind, what is your advice to lawyers and litigants about tilting at windmills? When I teach con law, I advise my law students, do not waste your clients' time and money unless they're really interested in tilting at a windmill and trying to go after, for example, New York Times v. Sullivan, because it's not likely to happen. What's your advice to lawyers and litigants on that, Justice?
I think that's true. And lawyers and litigants, of course, their chances of getting up to the Supreme Court are pretty slim. They're starting in district courts, and district courts have to abide because of, vertical stare decisis. They have to follow and apply the decisions of the Supreme Court, and so do the courts of appeals. And the lower courts are not going to, and they don't have the authority to contradict existing Supreme Court precedents. And then there are 4,000 cert petitions filed a year. The court takes 55 or 60 of those. So you're really tilting at windmills to spend all the money litigating it all the way up and then trying to run through the narrow gate to get on the court's docket, then unless you're pretty certain that you have a case that's on such shaky ground and that the court has signaled would satisfy the high standard for overruling, I don't think it's probably a good expenditure of clients' money to tilt at those windmills.
Now, Justice, it's been a very busy summer for the court when it normally isn't. Your colleague, Justice Gorsuch, who's been a guest on this program, issued a rather sharp concurrence in an emergency docket case this summer at district courts who are not abiding by settled case law. Was this unusual in your experience of the past 5 years, and ought it to stop, and do you think it will?
The emergency docket has been going on. These emergency motions where litigants come to the Supreme Court and seek relief on an interim basis, before litigation has been completed in the courts below. It's not new to the past 6 months, but it has definitely accelerated in the last 6 months. I think it's a bad way to run a railroad. I'm not sure if it's unavoidable, and we have to rule on the motions that are filed. We can't ignore them. So I don't see a way for the court itself to extricate itself from this process. How one could stop it and channel this litigation differently, I think, is something that's largely beyond the court's control. So there's just been a lot of litigation. There have been a lot of executive orders, but there's been a lot of litigation, a lot of many, many injunctions entered by lower courts. And so that's just contributed to a state of affairs where we've been very busy over the summer.
Now, Justice, you went out of your way to make this listening to the law accessible. And my highly annotated book here, accessible to non-lawyers. And I appreciate that because if people don't often understand the work of the court. So I want to cover a couple of things that you said that might be just beyond the grasp of a layman. Page 141-2. By adopting the Bill of Rights, the founding generation made the Constitution a more morally laden document. Americans wanted specifics, and they wanted them in writing, promises that the federal government would not violate the rights that Americans considered most sacred. Morally laden document. I think I know what that means, but what do you mean by that?
Well, I think the Bill of Rights, for those in the audience who are not lawyers, the original Constitution dealt only with the structure of the government, set up Congress and the presidency and the judiciary, but it didn't protect our rights. The Bill of Rights, the First Amendment's guarantee of freedom of speech, for example, was not part of the original document. And the Bill of Rights, certainly those amendments and then many of the amendments that we've added since actually expressed the values and the principles that we as Americans hold dear. And that's what I meant by morally laden document, one that actually expressed value judgments and didn't deal simply with the structures of government itself.
Now, when I teach fundamental rights, I'm going to be using your commentary on Washington v. Glucksberg, which is a 1997 case, special protection for some fundamental rights that, while not mentioned in the United States Constitution, are nevertheless, and I'm quoting the case here, not you, though you quote it, deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Is that an open-ended invitation to sift through and root about the ratification debates, for example, or among the 7 of the 8 amendments that were originally proposed by Madison that didn't make it into the Bill of Rights or the 1992 ratification of the long dormant amendment? Would the framers, what do you think? Do those matter?
Well, let's see. Washington versus Glucksberg was an attempt to narrow and channel the court's activity and to try to take the court out of the business of rummaging around in the area of individual rights and to channel that authority so that the court was not, for lack of a better word, inventing rights or simply plucking out and imposing rights that the justices thought should be valuable, imposing them on the people by incorporating them into the Constitution.
And do you think that that will be a limiting principle on, Judge Bork used to say the Ninth Amendment's an inkblot, and I'm not really in a hurry to open up the Constitution for non-originalists who want to import today's moral milieu, whatever it might be, whatever they think it is, into the Constitution. Is the Glucksberg precedent the one you want people to understand? It's got to be deeply rooted in history and tradition, really anchored.
Absolutely, because the Glucksberg precedent is the court's latest, and it is the controlling statement of what the court's approach is, the methodological approach to interpreting the 14th Amendment's due process clause, which under current doctrine is the source of unenumerated rights. And by unenumerated rights, I mean those that are not spelled out in the Constitution, in contrast to freedom of speech. Those rights like the freedom to marry, which is not expressly mentioned in the Constitution, but under the Glucksberg test, one might say, well, that's deeply rooted in our history and tradition at the most specific level. So yeah, that is what the court has said is the test.
Now, Justice Barrett, the two parts of the Constitution that I think have strayed the furthest from the original intent, the Free Exercise Clause, which we've already talked about, but also the Takings Clause. And do you think the framers, or even the Anti-Federalists especially, would recognize modern jurisprudence since Village of Euclid? I don't think they would.
There are a lot of things about our jurisprudence under the Takings Clause and probably and certainly outside the Takings Clause too that the founders would not recognize.
Do you call that out as a part of your instructions to clerks? Let's make sure we call out this area and how it connects back to the framers when you're giving them instructions on research and direction for the bench memos?
I do not, because one principle that controls in judging is that precedent applies unless, you and I were talking a few moments ago about stare decisis and whether it's tilting at windmills for litigants to ask for precedent to be overruled. We certainly have some cases in which we overrule precedent, as you pointed out, on average, one a year. But if we are not expressly considering whether to overrule a precedent, the court's practice is to take all of our prior cases as settled and go from there. So I don't tell clerks to go back and set all the precedent aside and dig down to the original meaning, starting, in other words, from scratch.
Okay. Now, this is a subjective question completely. I used to be dazzled at the D.C. Circuit by the quality of the oral argument. I was just amazed at the lawyers. And I've only been in the Supreme Court audience on one occasion. Is there a difference in the quality of the Supreme Court bar from the bar in the Seventh Circuit or the D.C. Circuit when you were a clerk, or are they all pretty much 5 stars?
If you ever want to come to another argument, Hugh, consider it an open invitation. As for the quality of lawyering, I would say there were certainly some fantastic advocates that I saw at the Seventh Circuit. But on the whole, I have very rarely seen in my 5 years on the court someone who was anything less than an excellent oral argument. The Supreme Court bar tends to be fairly specialized, and so it's populated with very talented appellate lawyers. And there are so few cases at the court, so few cases get oral arguments, that there's a lot of competition among those lawyers to get the cases, as opposed to the Seventh Circuit, where we hear many oral arguments. And so, there are just more lawyers participating in the process, and it's less specialized.
Would you be willing to opine on this, Justice Barrett? Usually when the court grants cert, my advice to anyone who's ever asked, and it's happened a few times over the years, do I go with the lawyer who got me there, or do I go find a specialist? I invariably say, go hire Paul Clement if you can, and if you can't, go hire someone he recommends. Do not take your lawyer from the appellate division, no matter how good they are, or how long they've stuck with you, or how loyal they have been to you, and how they've let you ride along for free, because it's a different skill set. Do you agree with me, or do you think you ought to give everyone a shot to go up there?
Well, let's see. I think it's generally pretty high risk. I agree with you to stick with the lawyer that was with you below, because it is different to practice in front of the Court of Appeals, and certainly in front of a trial court, than in the Supreme Court. I'm hesitant to say that you should only consider existing Supreme Court litigators, because then that would make them a closed set and it would make it hard for anyone else to break in. But I certainly don't think you should just default to sticking with the lawyer you have. And I think it would be a good idea to ask Paul Clement or any other experienced litigator from the court if there's someone that they recommend. I wouldn't be afraid to give someone a chance. There are often, because arguments are such a scarcity, there are often many young, ambitious appellate lawyers willing to take a case pro bono at the Supreme Court simply to get an opportunity to make the argument.
Now, I was surprised in listening to the law that oral argument can indeed and has changed your mind. You want to expand on that for people? Because I've always thought it's kind of fun for me and for other people who follow the law to listen to them, but I wasn't really sure that it was other than a debating technique for the conference that was going to follow.
Sometimes it does change my mind. Most often I would say when oral argument does have an effect on me and kind of moves me from the place that I was when I went into the oral argument, having read the briefs and all of the legal authorities, I think it's most often in the scope of the decision or how the decision is going to be decided. But sometimes it actually moves me on the bottom line. And I think, it's a mistake to think of oral argument as just a throwaway.
Now, I want to have you argue a little bit with Justice Breyer by remote. He was on this program when he came out with his book, and we got around to talking about the internet, and his argument was George Washington didn't know about the internet, and my response was George Washington knew about liberty. What do you make of that exchange? Because it's my favorite exchange maybe in 25 years of radio.
Of course, George Washington didn't know about the internet, and neither did any of the founders. But if we're thinking about, for example, freedom of speech, that principle applies beyond, the pamphleteer. The internet is a way of communicating ideas, and so freedom of speech and the language, and as you say, this idea of liberty, the freedom that we have to speak and communicate our ideas and argue, applies to the internet just as easily as it does to, the town crier passing out pamphlets in the town square. I think it's a caricature of originalism to say that we must interpret the Constitution only through the eyes of problems that the founders could foresee.
So, Justice, we don't want to talk about the specifics of the murder of Charlie because it may end up before the court. But we do have a First Amendment regime where you really can't act against the speaker unless they have the intent to cause violence and the imminent ability to do so. It's a pretty tenured decision now. As the internet progresses and the deep web becomes darker, and all of these crazy chat rooms develop that we have seen in the news, what do you advise, to the extent that it is appropriate to do so, Congress to think about when they think about regulating the web?
Well, as you say, Congress's ability to regulate speech is circumscribed by the First Amendment. And so the court has any number of cases. In fact, we had one last term involving the regulation of children's access to porn, which happens, of course, mostly online. I'm not sure that regulation or legislation is going to be the most effective way to stamp out, just as a policy matter. I don't know that that's going to be the most effective way of stamping out some of the cesspool that we have on the dark web and on the internet generally, just because of Congress's restraint. I mean, because it's constrained by the First Amendment.
Let me ask you as a mother, not as a justice. What have you and your husband done about internet access for your children? Some of whom are adults now, but I mean, it's a real deal for my children now that they have children, and I sit in the back saying, "Don't let anything in the house. Don't let them have anything." But it's not really practical.
It's one of the most difficult things about parenting in the modern era, I would say. We use screening software that we check. We have parental controls on their phones. We try to have very tight control over the TV. We have time limits on their devices. And it's still very difficult to keep up with, all of the things that they do online. And my kids are very good, but you can very easily inadvertently wander. So it's important to be vigilant. We don't allow them to have social media until we've kind of set around 16 as the age. One of my sons recently got Instagram, but the condition was that he read The Anxious Generation with us. We watched a documentary together about the effects of social media on teenagers, and then we had to have a discussion about it. And he's only allowed to be friends on Instagram with people who he knows. And we check and he has to be friend. I don't have social media, but my husband has an Instagram account solely for the purpose of tracking what our children are doing online. And he has to allow my husband to be his friend.
John Haidt is one of my heroes, and I think Governor Youngkin, I'm a member, I'm a citizen of the Commonwealth, has done us a great favor by urging every school in the Commonwealth to ban phones from campus. I don't think I take you into the shoals of commentary that you may not issue. What do you think of that advice from the governor?
Well, the school that my children attend requires them to leave their cell phones in the lockers at the beginning of the day, and they can't get them back until the end of the day. So if a parent needs to reach a child during the school day, has to do it through the office. And I think that's excellent advice. I can't imagine how children can focus on learning if they have access to a cell phone. So I wouldn't allow my kids to take their phones into school for that reason, just as a parent. I'm speaking as a parent. I think it's been a very good practice for my children to have that rule.
Now, I want to make sure I get to a few things that I did not get to last week in our remaining 12 minutes, Justice Barrett, and thank you for the time again. Listening to the Law is a fabulous book. The best days are days when joint memos come in quickly without requests for changes. How often does that happen, and are you ever surprised by a justice, a particular justice doing it on a particular case that's been discussed in conference?
So joint memos coming in without requests for changes, the more complicated a case, the more likely you are to get requests for changes from your colleagues. So I describe in the book one particular occasion in which joint memos came in quickly. And to be clear, I don't say which case that was, but where joint memos came in particularly quickly. So my law clerks and I popped a bottle of champagne to celebrate
Huh?
once we had everyone in on the case.
I said, not often now. Questions for law students who are out there. If they are not intending to do a clerkship, should they even think about law review?
I think law review teaches some valuable skills. I find, and I found this in practice as a young associate and watching others with whom I worked, it teaches a real attention to detail and to editing. There's just, in fact, my husband did clerk, but he helped me. He read chapters of the book, and he was the editor in chief of the law review. And all of these years later, he still has such a sharp eye for editing and for grammar and for, spaces that shouldn't be in there, that I do think that there's value to it. I also think it opens the doors. It is for better or for worse, it is a gold star on your resume that will open doors to jobs at law firms and other places because it marks you as someone who's a good student and attentive to detail.
Now, you can't choose to become Order of the Coif. That's just something that you get. But moot
Mhm.
court absorbs a lot of students' time in enormous amounts. What is the value of that after 15 years in the classroom and almost a decade on the bench now?
I think moot court, there aren't that many opportunities in law school to do things that actually mimic what you would do as a lawyer. In moot court, you're writing briefs and you're making arguments to a judge or to a panel of judges. And I think that's good practice. I think to allow any particular activity to suck up so much of your time that you don't have enough time to devote to your classes is a bad idea. But the opportunity to see what it's like to argue in front of judges and be articulate on your feet, I think can serve you well in your career.
So, Justice, now I want to talk about the 9,000 law professors and the faculties that they make up and the committees on curriculum on which they serve. There's been quite a lot of change in recent years, but no one is in a hurry to add American history, despite my many urgent uh, suggestions that they do so on this program. What would you delete from the law school curriculums generally, and what would you insist on a 2L or a 3L taking that is not right now required?
So I taught, for listeners who are unaware of my background, I taught at Notre Dame. I can't remember if we talked about that earlier. And my experience then is limited to the curriculum at Notre Dame. And I wouldn't want to offend any of my former colleagues by saying I would cut their class. But I do think that there are certain classes that all students should take, and there's been a move among law schools to not require classes anymore, except for very few. Certainly, the classes that are the traditional first year classes, civil procedure, torts, contracts, the basics need to be taken. But I think a lot of law schools have added courses in like legislation and regulation. I think that's really valuable because most of what young lawyers are going to do is deal with statutes and deal with administrative regulations. I know you've had Justice Gorsuch on, and certainly he's written a lot about how many regulations that we have. So I think you need to understand that. I think administrative law really is a whether you're going to do a transactional practice or whether you're going to litigate, you have to know how to deal with regulations. So I think, and statutory interpretation, that's something that I taught for a long time and that I still teach. Everybody has to deal with statutes. That's a very practical skill to know the kinds of arguments to make and know your way around textualism. And we mentioned Justice Breyer and Justice Breyer's pragmatist approach. You need to know how to argue before judges who take both different approaches.
You quote Judge Friendly quoting Justice Frankfurter. The basic rules of statutory interpretation are simple. One, read the statute. Two, read the statute. Three, read the statute. It's sort of a Breyer versus Barrett over the validity of including how one uses the text. And I think you're both I'd like to see that debate. Do you talk with him as a retired justice with chambers still open and he's still working hard? Do you talk with him about these things?
I do, and actually, we have had that debate. We participated in an event at the court in front of a group just last year, and we did a discussion. It wasn't so much a debate as a discussion about textualism versus Justice Breyer's more pragmatic approach.
I will look for that online. Bravo as well on a succinct, persuasive argument for the ongoing exile of legislative history from Supreme Court decision making. Can you explain to the audience why it doesn't matter that Senator Cotton says to Senator Graham X is allowed, or that Senator King says to Senator Van Hollen Y is allowed? Why does that not matter to you?
Well, as a formal matter, the legislative history has not gone through both houses of Congress and been signed by the president. It's not itself the law. And, as a practical matter, it's just the views of, in your example, say, Senator Cotton. It's not the views of a majority of both houses of Congress, and anybody can say anything they want in the legislative history. Often legislators themselves don't know what's in the legislative history. It's put in by staffers who might have gotten it from interest groups. And sometimes, I talk in the book about an example that I used to use in my statutory interpretation class. Sometimes it's a fiction. There are instances in which legislators insert supposed colloquies and dialogues that they have with one another that never actually happened, and they insert them in the record after the fact. So it's just not a reliable tool, apart from the fact that there's no constitutional basis for treating it as authoritative.
And does that, in fact, become even more relevant a consideration the longer back you go in the legislative history? Because the legislative history wasn't all that good, and the records weren't all that exact in the days of the early Congresses. Do we look even more askance the older the legislative history?
That's funny that you asked that question, because there have actually been studies. The court didn't really start looking at legislative history until Holy Trinity versus United States, that notorious case. That was one of the first cases that really looked at legislative history, in addition to the dubious approach that it took to interpreting statutes at all. It was after that case that legislative history started to balloon, and some scholars have argued that there was a feedback effect, that the more the court cited legislative history, the more Congress created legislative history. That makes it more suspect, in my view.
I want to close, Justice, by getting to the heart of your argument about originalism, which I think is on page 200. In my view, departing from the original meaning differs in degree but not in kind from departing from the text outright. The primary difference between originalism and other approaches is that originalists treat historical meaning as determinative, while non-originalists sometimes prioritize other considerations such as purposes or values underlying a constitutional provision. Is that the heart of originalism?
I think it is, yes. I make the point in the book, which I do think is an important one, that all justices, even those who don't consider themselves originalists, at least all justices to my knowledge, take history into account. So I think sometimes people who are outside the court caricature originalism by saying, oh, well, only crazy originalists consider the history. That's not so. But originalists do treat the historical meaning of the text where it's determinative as conclusive, whereas, for example, Justice Breyer in his most recent book makes the argument that, well, that's one thing to consider, but there might be other considerations that would overcome the historical meaning.
So I want to do something, which is to give time back to a justice, not unlike giving time back to a court, 2 minutes. And I want to know, when you hear that, I'd like to give time back to the court. Are you happy, or are you sad, or are you surprised?
You mean when you've given time back to me?
No,
or in an
no, when
actual
someone in the
argument?
court, when an oral argument says, I'm going to give time back to the court. Do you like that?
It happens very, very rarely. I'm trying to remember if it's happened before the court. Yeah, it's happened before the court. And usually I think that's a sign of strength, because a lawyer who does that recognizes the strength of his position and that there's nothing more to be said, or can read the bench, knows how to read the room, and sees that the justices themselves have no further questions. So it's usually a good thing.
Well, Justice Barrett, thank you again for your time. I will be replaying our Nixon Library conversation. Between the two of them, I will have asked and answered all my questions. Good luck in the term ahead, and I appreciate the time very much. Listening to the Law, a great read for everyone. Thank you, Justice Barrett.
Thank you, Hugh.
The Richard Nixon Presidential Library Museum and the birthplace of our 37th president. It's a pleasure to have you all here this morning. My name is Joe Lopez. I'm the acting president and CEO of the Richard Nixon Foundation, and it's a special privilege to have the Nixon Foundation host an Associate Justice of the Supreme Court of the United States here this morning. because, as you saw in that video, we believe civics education is essential. The strength of our democracy depends on citizens who know their history, who cherish the Constitution, and are prepared to safeguard the freedoms that we hold dear. This is why the Nixon Foundation has made civics a central part of our mission, to ensure that the next generation not only inherits a free country, but has the knowledge and character to preserve it. To those of you in this room who have supported our civics mission, thank you. Your partnership makes all of this work possible. And there could be no better way to underscore civics today than by hearing from Justice Amy Coney Barrett. In conversation with our friend and board member, Hugh Hewitt. Please join me in welcoming Justice Barrett, her husband, Jesse Barrett, and Hugh Hewitt to the stage. Ladies and gentlemen, please remain standing for the presentation of colors by the Orange County Sheriff's Department Honor Guard, followed by our national anthem by the Huntington Beach Concert Band. Thank you. You may be seated. It's now my pleasure to turn the program over to Hugh Hewitt.
Thank you so much, Joe, and welcome everyone. Justice, it's an honor to have you at the library. Thank you for joining us here. I want to begin by asking, when you're addressed by counsel during argument, do you prefer to be addressed as Justice Coney Barrett or as Justice Barrett?
Justice Barrett.
All right, so I'm going to stick with Justice Barrett. To remind our audience, you are a daughter of New Orleans, proud member of the Roman Catholic Church, for which as a fellow Catholic I am grateful. You are a Notre Dame law graduate, 1997, Rhodes College, 1994, St. Mary's High School in New Orleans. Were you in parochial schools in New Orleans before that?
I was, yes. So Catholic school, Rhodes is not a Catholic school, but Catholic school K through 12, and then, law school too.
I want people to know as well that you clerked for Judge Silberman, who served as the Deputy Attorney General for President Nixon, and Justice Scalia, who served as the General Counsel of the Office of Telecommunications. So we count you as part of the Nixon coaching tree. Thank you. And given that you're here at the Nixon Library, it's only appropriate. My first question would be from page 81 of Listening to the Law, a superb book, about Alger Hiss. Because you write that Alger Hiss, I did not know this until I read Listening to the Law, was a clerk to Justice Oliver Wendell Holmes, and then you put in parentheses, later a Soviet spy, Alger Hiss, later a Soviet, and his job was rather like a 19th century private secretary in upper class British life, included an odd assortment like scouting his future resting place. But you used that parenthetical, later a Soviet spy. First of all, thank you, he was. But on what did you base that conclusion? Because the debate still rages in the world.
The debate still rages, but it seemed like the evidence suggests that he was, correct?
Overwhelmingly.
Yes, and you know, the book was thoroughly fact-checked by me and a fact-checker that I hired, and that made it pass.
Now I'm going to cite it when I always ask my guests, was Hiss a Soviet spy? And if they don't know, they just don't know history. And if they're from the left, they say no. And if they're got a brain, they say yes. I listened to Barry Weiss's interview, and I would recommend all of you to go to the Free Press, join the Free Press, and watch the interview with Justice Barrett. So I'm going to try and not be duplicative. However, you don't have any social media? You told Barry that.
I don't have any social media.
Does anyone in the family?
My children do. My college age, we just allowed my 16-year-old son to get Instagram, but we try to limit social media. I had Facebook, like all older people, I guess. The young people don't use Facebook anymore. I had Facebook before I became a judge, and then I deactivated that when I went on the Seventh Circuit, and I find it's probably better for my mental health not to have any other social media.
I was wondering how the children worked out with that, because my grandchildren are already lobbying and they're 14. I want to go back to clerking.
Yes.
Page 84, Justice Scalia's chambers, when you served there, every battle is fought out like an Italian street fight.
Yeah.
But you describe your clerks as eating on their laps in your chambers, talking about books, family, Netflix queues. What do you look like? What do you look for in a clerk? And Dean Patton and President Parlow will be listening very closely. What do you look for in a clerk?
Well, for Justice Scalia, that was a quote that showed up in a Washingtonian magazine article about clerks at the court. That Italian street fight was about the merits of cases. But when we went out to lunch or when we hung out in chambers, it was a much warmer conversation about regular topics. So for my clerks, I do want pushback when we talk about cases. I wouldn't say that I run an Italian street fight in my chambers. I'm a little bit more mellow than that. But I want clerks that are going to be collegial with one another and that are going to represent chambers well in interactions with other chambers, continue that collegiality, but be willing to push back, you know, when we're talking about ideas.
So, Justice Barrett, I want to let people know that the beginning of your book is the Greenhouse Street house in New Orleans. Your great-grandmother had 13 children. She was pregnant with the 13th when she was widowed. And you explain, and people should read it, anything is possible in America, because you really wouldn't expect her great-granddaughter to be on the court in those circumstances. I'm curious, did the local church help her at that point in New Orleans?
Not that I'm aware of, but she did. She was not well off. She was fairly poor. This was during the Great Depression, and she was widowed, and not all 13 children were living at home in the time because there was an age range. But it was a very crowded 3-bedroom house. She helped a lot of people in the neighborhood, the poor men, you know, known as hobos back then, who would come through. She would feed them and somehow always managed to have enough food to feed her crowded house and the hobos. I think she got a lot of support, like, from the neighborhood. They were all close and helped one another. She may well have gotten some support from the church, too.
My grandmother Grace was a friend to hobos, and that's the family lore. There was a mark that they would put on the house.
She had the mark, on the house.
But she wouldn't let them sleep under the house.
She let them sleep. It's a raised house in New Orleans because of hurricanes and flooding. We have many raised houses. Her house was what you call a shotgun house because you can stand at the door and you can just look straight out to the back. And it was raised, and she did let them sleep under the house, but then one of them fell asleep with a cigarette in his mouth and started a small fire. So after that, she would feed them on the back porch, but did not allow them to sleep under the house.
It's a fabulous story. your grandparents had a house there different from your great-grandparents, and it had to be torn down after Katrina. So I say this by the way, you're deeply rooted in the South. I don't remember that from the confirmation process. It certainly isn't in your accent. How far back, I mean, are you a Southerner? Do you consider yourself a Southerner?
You know, it's funny, New Orleanians don't necessarily consider themselves Southerners in that same way, because New Orleans, because of the French and Spanish influence, has a little bit of a different feel than some of the other Southern states. But I spent time in Memphis too, so I claim the South as my own. But we went back for generations. I think it was my great-great-great-grandmother and her husband who came from France. And I also have some Irish in me and a little bit of German, but on both sides of my family, on my mother's side and my father's side, it's multi-generational. New Orleans is that way. I mean, up until Katrina, people really were very rooted there and stayed there for generations.
Now, I bring up the Southern because the confirmation wars actually began when President Nixon nominated Clement Haynsworth in 1969, and he was rejected largely on regional grounds. There were some arguments about decisions. Right now, and you note on page 78, 6 of the 9 justices clerked on the Supreme Court. I note 8 of the 9 were steeped in Beltway. You're the first, Judge Kethledge and I had talked about this, you're the first non-Beltway person in a very long time. Is it good for the country to have such a Beltway-centric bench?
Well, I think all of my colleagues, well, Justice Sotomayor wasn't particularly Beltway-centric, I would say, because she hadn't, that I know of, worked in an administration. But I think that it's probably good for the court to have variety, but certainly all of my colleagues who were Beltway-centric, you know, I value them greatly.
Right. Well, obviously. I would like, a senator who will remain nameless said he wants originalists from the Midwest to be every judge, or if they have to be outside of the Midwest, they have to be like Justice Alito, meaning just the law. The Seabag is the name of the annual yearbook at the United States Naval Academy. I don't know if you know that, but it's also the name of your grandparents' a book about them consisting of their letter. Your grandfather served on the Cimarron, I looked it up, first in his class of oilers during World War II, so he's a tempting target for the Imperial Japanese Navy, and he would write to your grandmother, and your grandmother would write back, and all their letters were preserved. You used that, well played, Ms. Bond, to introduce originalism. Would you explain that to the audience? Because I think it's so on the nose.
So my grandparents kept the letters that they wrote to one another during World War II in a sea bag, and it was in, we don't have basements in New Orleans, but it was on the first floor of their house that they used like a basement, and it flooded during Katrina. And so when the sea bag floated out and we were able to open it, the contents were largely preserved because the bag was made to be waterproof. And what Hugh is talking about, the way that I use that to talk about originalism, which is, you know, as many of you probably know, the jurisprudential philosophy that says you should interpret the language of the Constitution as it was understood by those who ratified it. The letters were from World War II, so they had some language in them that we didn't understand. And so one of my uncles, who was a retired newspaper reporter for the New Orleans Times-Picayune, took on the project of editing the letters and looked up many of the terms, you know, that we may not have known, and also many of the backstories that we wouldn't have known. You know, he describes at one point having a shaved head, and, you know, he couldn't say too much about it. There were sensors on the ship. He couldn't reveal where he was because that would obviously compromise security. My uncle has researched and figured out it probably meant they were crossing the equator, because when you cross the equator, the rookies who had never crossed the equator before would get their heads shaved, and one would dress up as King Neptune, one of the more seasoned sailors. But you wouldn't have necessarily known that if you didn't know some background about the ship and this ritual that was followed when they crossed the equator.
Crossing the line. I married into a Navy family. I'm a civilian, but I've heard about crossing line forever. And of course, you're going to be censored if you're on an oiler and you're a target. They don't want people to intercept that. But I thought originalism needs context.
Yeah.
And I thought that was brilliantly done. I mentioned you downstairs when you and your husband, Jesse, and I were chatting. I'm astonished that you can put all of your siblings and all of their children and your parents together occasionally in the summer. That's 50 people. So you're the justice. Do you get to decide who cooks and who cleans?
I get no respect. I don't get to choose which bedroom I want, which house I want, who cooks and who cleans. I am the oldest in my family of origin. I'm the oldest of 7, but yeah, I'm the bossy older sister that everybody likes to take their revenge on now.
Do they give you a hard time? I mean, is it, oh, Justice, I'll do this, or any?
They tease me sometimes, but I will say that I work hard to keep title of, say, fun aunt. We went to the Smokies on our family vacation this year, and we were very close to Dollywood. So my sisters and I took the nieces and my youngest daughter to Dollywood and rode roller coasters. And I worked really hard to be fun aunt, and I went on every single one with all of the nieces, and not all of my sisters did. And I felt like I had to prove something.
Well,
I'm the justice, but I'm still fun.
Listening to the Law is a superb book, and I think you wrote somewhere that cases are not math problems, books are not math problems either, but this is an excellent bridge for non-lawyers who want to be entertained and find the law accessible, and at the same time keep lawyers and judges on their toes. I'm going to geek out on you here. On page 39, you wrote, I've written concurrences to explain my own thinking about an aspect of the majority opinion or identify areas of the law that could benefit from development by advocates and scholars. And you cite Fulton versus City of Philadelphia. Archbishop Chaput is a friend, and so I've sent him a note that I'm very into this conversation today because you said, quote, in that decision, there would be a number of issues to work through if Smith overruled. Have any scholars come to your assistance since you wrote that?
Not that I'm aware of.
It was an open invitation.
That's what I hoped it would be. Maybe people are working on it.
Okay.
And there may be, I don't want to offend any law professors out there who have started working on it, and I'm just unaware, but not that I know of.
I gave a lecture on Smith about what you were talking at BYU in 1998, and I quoted Peter Berger, if India is the most religious country in the world and Sweden is the least religious, then the United States of America is a country of Indians who are ruled by Swedes. And of what you see in Washington, has it become a completely secular country?
Oh, probably the circles in which we move are not the best gauge of what Washington is. I mean, we are Catholic and we're very active in our parish, and so we have many, many friends who are, Jewish or Christian or Catholic and who are deeply faithful. But I mean, we all read the polls about trends of religiosity across the country and the drop. Although I've read a few articles lately that suggest there might be a bit of a religious revival in America and in certain European countries too.
Focus is the Catholic organization operating on campus and doing quite a good job. I am glad that the court, you don't have to comment, punted on the Oklahoma case because you were recused, and I'm looking forward to when Smith is overturned, and I hope that the assignment memo designates you. Would you tell people about the assignment memo, and have you ever gritted your teeth when it came out?
So the assignment memo, we hear cases in 2-week increments. So, we'll hear oral argument on, say, Monday, Tuesday, Wednesday, 1 or 2 cases a day. We meet in conference, on Wednesday and Friday, and we vote on the cases. And then the Chief Justice, or the justice who's the most senior justice in the majority, assigns the opinion. And if it's not the Chief Justice, he will coordinate with whoever that justice is to make sure that the work is equitably distributed. Well, I'm the second most junior justice, and as you might suspect, the second most junior justice does not expect most of the plum assignments. It's more, say the drier cases, and I won't single out, say, tax or something like that in case there's a tax expert in the room. But the junior justices don't expect the best assignments. But the chief does try to make sure that everybody gets something that will be of interest in the term. So, my law clerks will take bets, and they'll give me their predictions on which justice is going to get which opinion. They're often not right, but it's a big moment at the end of that 2-week period when the chief's assignment memo circulates and we get to see who has what.
One of the beauties of listening to the law, and Frank Luntz taught me, you're supposed to say the title of the book at least 7 times in any setting. So listening to the law does talk about how you have to grin and bear with a lot when you're the junior justice, but that the next junior justice does the welcoming dinner. And you arranged for Justice Brown Jackson, who loves Broadway, and you brought that up to Barry, You arranged for her to have a singer from Hamilton. I am just curious, you did not discuss the details of how that is done. How does one get a cast member of Hamilton to come to the court?
Well, she wasn't a cast member from Hamilton, but she sang Hamilton selections, and it was actually because my assistant was Justice Scalia's assistant too, and she got to know some of the actors who, when there was the production about Justice Scalia, yeah, there was a production about Justice Scalia, and there was also an opera about Justice Ginsburg and Justice Scalia, both of whom loved opera. But there was a play done about Justice Scalia, and just in the course of that, she got to know several people in the theater world. And so she reached out to some of those people she got to know when the production about Justice Scalia was being made, and then put me in contact, because I don't have contacts in my phone of Broadway singers. So that was actually very helpful to me.
Now, Barry referenced that there are often sharply worded exchanges between the justices, but you quote Justice Scalia. I argue with ideas, not about people. I'm paraphrasing there. Does that generally hold, or have you lost your temper at the court? I've done it a couple of times in broadcast, but never had to worry about with a judge with whom I must serve for the rest of my life.
No, and actually, I've never in the conference room heard raised voices, even in tense cases. So Justice Scalia was absolutely right, attacking ideas and not people. It struck me, and I said this at one event, that being on the court is like being in arranged marriage with no option of divorce. Because you don't pick your colleagues. I mean, that's why I describe in the book, Listening to the Law,
Bingo.
how I was nervous walking in the first day, because nobody, when you walk into every other job, you've been recruited. And the people with whom you're working wanted to hire you. You walk into the court, and none of the people with whom you'll be working had any say in whether you get picked. So it is like an arranged marriage, and because of life tenure, you will be with them for a long term, and that's a big incentive to get along.
Well said.
Apart from all the reasons of collegiality and civility, which are otherwise in play.
Let me turn now to originalism and begin with, is Abigail Adams still in your office?
She is. She hangs above the mantle.
Would you tell people about that choice?
Yes. So when I decorated my office, I decided I wanted to have something from the founding era up, because I deal obviously with the Constitution all the time. And as an originalist, at least when we're talking about the original Constitution, I'm thinking about what the Constitution meant to those who ratified it. And there were no women at the Constitutional Convention or in any of the state ratifying conventions, quite obviously. But Abigail Adams was a formidable woman in her time, and many of you have probably read the letters that she and John exchanged or seen that very excellent HBO miniseries about John Adams. She was so engaged in the affairs of the day, while she simultaneously was running the farm and raising their large family while John Adams was away. And there's one point in a biography of Abigail where it describes, once he became president, how she had a very difficult time, because she never thought that she'd move away from Braintree, Massachusetts, and live in the public eye, and she had a hard time adjusting to it, and that resonated with me too. So I have her in the office, and it also reminds me of the promise. You know, she couldn't participate in government, and here I am, mother of a large family, and I can.
It's a wonderful piece of the bill. When you're talking about Abigail Adams, you note that the founding era is a period important to your work, and you include the lived experience of the framers. You write a significant amount about the years 1787 to 1789, Federalist Papers, of course. Abraham Lincoln is in the book quite a lot, but the Declaration of Independence, which Lincoln called the apple of gold protected by the frame of silver, is not, but for the briefest of mentions on page 124. Does the Declaration matter to you as an originalist in how you judge?
So the Declaration of Independence certainly matters to me as an American, and it certainly forms part of the backdrop against which the men who met in the Constitutional Convention were thinking. I mean, the Articles of Confederation had happened before that, so we had the Declaration, and then when America was first established as a country, we had the Articles of Confederation were the document that formed the government structure, and then later the Constitutional Convention. But I don't think the Declaration of Independence, I mean, it's not, when it comes to law, I mean, it doesn't have the force of law. It hasn't been ratified as law. So while it's part of that context of the time, I don't regard it as something that has, that has the force of law as does the Constitution or the statutes that govern us. And I think that's a pretty important distinction, but I do think that some scholars, even some originalists, put different amounts of weight on the Declaration of Independence.
They do, and it's an interview, not an argument. So I will point to the Cooper Union speech where Lincoln draws on the Northwest Ordinance and the Declaration to rebut Dred Scott. And you talk a lot about Lincoln. How much does he matter to you? I know you named George Washington Barry Weiss as your favorite president, but how much does Lincoln's thought as the Union is unraveling? You talk about the Corwin Amendment, for goodness sake.
Right.
If anyone here knows the Corwin Amendment, I'll give you a free book afterwards. It's wonderful to bring it up, but how much does Lincoln matter to you?
Lincoln does matter, and it was a tough call when Barry Weiss asked me that question, whether to say Washington or Lincoln. Those are the two, traditional choices, right? No, Lincoln does, and, Lincoln steers the country through secession, which is the constitutional crisis that we have faced in our history. And Lincoln is important, too, because it's Lincoln's work, and it's during, in the wake of Lincoln's presidency that we have the greatest amendments to the Constitution, which are the Reconstruction Amendments, which not only extend civil rights more broadly, but they also shift the balance of power because suddenly after the Reconstruction Amendments, and particularly Section 5 of the 14th Amendment, the states, because after the Civil War that was necessary, the state's relationship to the federal government changes somewhat. And Lincoln sets the backdrop for all of that.
Yeah. I'm very curious to see where it goes. Blackstone gets all the love, 500 citations, but no declaration. Let me switch to something I want to give you a bravo for. The most succinct defense of federalism ever is on page 160. Compare the characters in Portlandia to the Texans in Friday Night Lights. Would you explain what that is supposed to mean to people who've seen both?
Yes, so if you've seen the funky Portlandia and the, very American heartland football show, Friday Night Lights, set in Texas, what I'm trying to capture there is we have a vast country, and there are very great regional differences. The differences from those who live in Portland, Oregon, and, those who live in the heart of Texas. And federalism is the principle that because we govern ourselves at not just the national level, but the state and local levels as well, it allows us to account for those differences in America. I mean, one thing I tell my constitutional law students is when you compare the land mass and population size of the United States, I mean, I think sometimes students have come into my con law class thinking, yeah, we're just like the UK or we're just like France. And people wonder why we don't do everything at the national level. But if you step back and think about the size and amount of difference across the United States, federalism is what allows us, as I say in the book, to all get along under one roof because it leaves room for regional difference.
Justice, on page 51, you talk about the power of voices outside of the court. And I wanted to quote it, particularly those with the power to enhance or destroy reputation. Now, I know you footnote Adam Liptak, who's a very well-respected New York Times reporter, in their SCOTUS blog with Amy Howe. There are many fine Supreme Court reporters. But is there anyone who is not a lawyer or a scholar whose work you particularly admire in covering the court?
In covering the court. That's interesting. I feel like it could be a dangerous question for me to answer.
Make one friend who will be ungrateful and thousands who will hate you, yeah?
That's right. Yes, there are, I think the more neutral that you can be, I think then the better. So when I encourage, the best source is to read the court's opinions themselves. But when I encourage people, and I say this in the book, to follow the court closely, to try to find the most median source possible, or at least one that's transparent about its biases. Because it's very difficult if you're only consuming your information about the court and its decisions from the press and from outside sources to really get a full and accurate picture of what's going on.
Do you read books like Judge Thapar's book on Justice Thomas, The People's Justice, or Nina Totenberg's Dinners with... I'm addicted to books about the court. Are you?
I do read books about the court. I have not read Nina Totenberg's. I have read Judge Thapar's. I've also read many judicial biographies, because I find those really interesting, especially as I'm thinking, you know, as I have thought, and then transitioning to the role, about how I want to approach the job. So I read the judicial biographies as well, and the books by my colleagues like Justice Gorsuch.
And when you sit around with your clerks talking about books, are they reading books about the court, or do you encourage them to read broadly? You also cite, by the way, 2 novels by Stacey Abrams, and I said, wow, that's out of the park for me. Do you read thrillers?
I haven't read those thrillers. The reason I cite the Stacey Abrams book and some others, including one written by one of my co-clerks at the court, not for Justice Scalia, he worked for another justice, is to describe how people are fascinated with what law clerks do. And so Stacey Abrams had written some thrillers that involved law clerks at the court being involved in intrigue. No, I think my law clerks, at least during the term that they're clerking for me, don't do a lot of outside reading, just because there's so much reading. You know, the briefs, especially when you can account for the amicus briefs that get filed too by those who are not the parties to the case, it can take up an entire shelf for just one case. So I think the law clerks are working pretty darn hard, and they're not doing a lot of reading in their spare time.
I've never met a law clerk who didn't say it was the hardest year of their professional life, so I can't imagine doing it. Judge, let's talk a little bit about law students and law professors. We have Dean Patton from Chapman, President Parlow from Chapman, who was Dean Parlow before he became President Parlow at Chapman. What did you teach besides con law and statutory interpretation? Because your reputation as a teacher is extraordinary.
I taught civil procedure, I taught evidence, I taught federal courts, con law, statutory interpretation, and constitutional theory.
You were a 1L in 1994.
Thanks for reminding me.
But I'm way before that, so you don't have to worry about that. I'm just curious, you must have had some great professors who I'd love for you to shout out to. And then I know you had some lousy professors because there's a bell curve everywhere. I don't want their names, but what's the difference between them in your view?
I would say the professors who encouraged you, and I modeled my professorial approach after this, the professors who tried to get you to think for yourself rather than just telling you what to think. And so who would present, you know, say if it was constitutional law, present the arguments on either side. You read the majority and the dissent, and you don't show your cards about which one you think was right. You let the students in the course of the class figure that out. So I tried hard not to let students know what I was thinking. It's harder now. I still go back and teach. I taught a class at Notre Dame in August, and they kind of know what I think now because my cards are all out on the table, but I still encourage them to push back.
Which real inside baseball casebook did you, I used Barnett and Blackman. Which one did you use, and did you switch often?
Barnett and Blackman were not out when I was teaching con law. That postdated my teaching. And, oh gosh, I'm embarrassed to say I've forgotten which one I used.
That's fine.
Oh.
I am stunned that you did federal courts in addition. I've never taught federal courts. Judge Kethledge teaches it at Michigan. Professor McConville, also a Supreme Court clerk, teaches it at Chapman. Is that the hardest course to teach?
It is a very hard class to teach. It's really hard. It draws the best students because it's so hard. It's one of those classes that sometimes, because classes are graded on a curve, students look around and see who else is in the class, and then they drop it because they don't want to be on that curve. It's a difficult class, and I used Hart and Wexler for that one.
Any lousy characteristics that follow lousy professors?
I think telling students what to think, and I think I gather from some students, some law students who go to schools which shall remain nameless, but law students generally, I think, sometimes have the experience, which actually I hear from college students too, of having professors who not only don't present both sides, but who ridicule one side, so it doesn't give students the opportunity to really choose between ideas themselves, and then kind of has the experience of, or the effect of silencing those who might be inclined to the view that's contrary to the professors. And so that's one I try to avoid. And also just being boring doesn't make for being a good professor.
So you went from this wonderful sedate life of being a professor at a wonderful university, top-tier law school, to the Seventh Circuit. You're married to a prosecutor, so you know what that's like, and you get the call asking you to be a justice. And you write about burning the boats, and Barry talked to you about it. But for the benefit of this audience, can you explain that difficult decision? Because it's not one that a handful of people in our lifetime face.
I think that some people assume, and maybe some people experience it that way, that when you're asked to interview for the Supreme Court, that it would be nothing but unadulterated excitement and joy. I did not experience it that way because, as Hugh says, we had a wonderful life. It was a sedate life in South Bend, and I knew the confirmation process could be excruciating and very difficult. It felt like going into a battle. I knew that if I were confirmed, that there would be very difficult things about being on the court, and we would be leaving South Bend. One of my friends from South Bend, who's not a lawyer, we joked that living in South Bend is kind of like living in the Shire from The Hobbit. You know, it's kind of remote, it's kind of sleepy, but it's a really nice place where everybody gets along. And then, you know, I was going to be like Frodo, dragging myself across the plains of Mordor through the confirmation process. So it didn't sound really appealing, that part of it in the moment, although certainly the prospect of serving our country was something that moved me and appealed to me, and that is why Jesse and I ultimately decided, you know, that yes, it was something we were open to, and I would go ahead and accept the interview.
The difference between you and Frodo is he got to leave Mordor. You have to stay.
And my friend pointed out, she's like, well, I'll be Samwise to your Frodo, and you can do it. And I said, but Frodo had to leave with the elves because he was so traumatized by the whole experience.
So you're a Tolkien person. A Catholic question. You were a Seventh Circuit judge in Notre Dame. Is Pope Leo XIV under your jurisdiction? I think he's from Chicago.
He is from Chicago, but his grandparents were from New Orleans, so my family text chain was exploding after Pope Leo was chosen.
What did you react as just an individual Catholic in America to an American Pope?
I thought it was really cool. I didn't think we would have an American Pope, so just as a Catholic living in America, I thought that was really exciting, and I think it makes people, and I'm excited for my children, feel more connected to the Catholic Church.
I want to go back to your clerks because I want to look forward ahead in the law. You write at one point, I think that Americans of all backgrounds deserve an independent Supreme Court that interprets our constitutions and laws as they are written. When you are hiring clerks, you're playing the long game. In 30 years, they'll be on courts, they'll be in office, some of them might be on SCOTUS. What do you look for in a Supreme Court clerk?
Well, just the base level is that they're very, very good lawyers. You know, I want clerks who have done well in law school, who can write well. I want clerks, as I was mentioning before, who are strong enough to disagree with me and not feel cowed. I don't want yes men and yes women. I want them to, that's their job, is to help me get it right. And I want clerks, you know, it's important to me to have clerks with discretion, who are discreet and who I can trust. And I always ask them when I'm interviewing them what they see themselves doing. And some of them say they want to stay in Washington, and that's fine. And I certainly do hope that I have clerks who will serve the country in some way, be it in an administration or as a federal judge. But I also like it when clerks say that they want to go back to the state where they're from, because maybe that's back to the let's not be Beltway-centric. I like the idea, too, of sending clerks out all over the country to do good things because they've had the opportunity to witness up close and personal the way that Supreme Court decisions are made, and that's very valuable for a lawyer.
Is it a good thing to only hire people 2 years removed from law school, or do you ever dip down into people who've been in practice for a few years and bring them in?
So it's interesting. I was hired when I was a third-year law student by Justice Scalia. So some justices do hire their law clerks when those law clerks are still in law school, and the typical path is that the clerk will then clerk for a Court of Appeals judge first, as I did for Judge Silberman, and then move on to clerk at the Supreme Court. Sometimes clerk for 2 judges before getting to the Supreme Court. And I say in the book, as Hugh says, I'll say the name, Listening to the Law. I say in the book that people often wonder, what is the value of having inexperienced lawyers as clerks? I think the value is the power balance stays the right way. I do want them to challenge me and push back, but if you have clerks that are older, they may expect to have a bigger say. Much like if you're at a law firm and you have associates who are very senior, they start taking the reins. But at the court, we make all of our own decisions. When I go into the conference room to vote, it's only the 9 justices in there. It's no law clerks. Clerks never get to go sit on the bench and pinch hit for me at oral argument, go in and cast the votes. So I actually find it's worked pretty well for me. I do sometimes have clerks who have practiced for a year or two before they come to me, but I don't deliberately seek that out.
Now, it's not in the book that you were hired as a 3L by Justice Scalia. So I'd like you to tell us a little bit about that interview, because that's got to be daunting to fly from South Bend to Justice Scalia's chambers if you did that.
Oh, I did do that, and it was extremely daunting. The way the interviews went is Justice Scalia's law clerks prided themselves on just being murderously difficult in the interview. So they were the bad cops to Justice Scalia's good cop. So you go in, and here I am, a third-year law student, and these are very, very smart law school graduates who have, been clerking at the court for the better part of a year and had experience in a court of appeals before that, and they just grill you with hard hypotheticals the whole time. For about an hour, you're sitting on one side of the table, and they're sitting on the other side of the table, and they're just shooting questions at you. And then you go into Justice Scalia's office, and I had not met him before, and he asked me mostly softball questions, but then he did say, what is one area of the court's jurisprudence in which you think we're getting it wrong? Oh. And I didn't know that question was coming, and I hadn't thought about it. And I picked the religion clauses, which is the most complicated, the most complicated question. He said, well, how would you do it better? And then I was stumped.
And you're still asking in Fulton versus Philadelphia.
I'm still asking that question. But I got the job anyway, so that was an exciting phone call.
There are two very profound things. There are many good things, but two profound things I want to talk to you about. Page 44, collegiality isn't always an act of the heart. It is sometimes an act of will. I believe that to be true. Would you explain why you believe that and how it manifests?
Yes, so that's a lesson that I learned from my parents in the context of forgiveness. I had mentioned before, I have 6 siblings, and we would, unsurprisingly, get in fights. And when my parents would make us apologize to one another, the most common refrain, which I hear from my own children, is, well, I'm not sorry. And they would always say, forgiveness and apology is an act of the will. You don't wait until you feel like it. And I think that's true in the way we treat each other, and I think that's true in friendship. It's true in every relationship, marriage, friendship, and colleagues at work. And so I think sometimes it takes discipline to feel collegial. I say in the book, I was advised, we have lunch together after oral arguments and after conference, and I was advised early on that sometimes it can be difficult to go after a difficult vote, after a difficult conference vote, but those are the days when it's an act of the will, when it's most important to go, because if you have a difficult vote and you've lost, say, those are the days in which you can let the roots of discord get sowed and blossom.
I've been laboring under the misimpression for decades that in conference, the junior justice starts first. And you corrected that for me. Would you explain to people how conference operates?
Yeah, the conference operates with the Chief Justice, who's always the most senior justice, no matter when he was appointed, going first. So the Chief Justice speaks first, and then it runs down the line in order of seniority. So I go 8th, and Justice Jackson goes 9th. And each justice describes how they see the case and, ticks down the line. When I was on the 7th Circuit, it was the opposite. On the 7th Circuit, the junior judge on the panel spoke first. And usually you hear cases in 3-judge panels, unless the court sat en banc, which is every judge on the court together. And we would always go most junior to most senior.
I'm curious, when President Parlow and I visited the chief a few years ago, he was careful to point out that the conference room really belongs to him. Does he remind you of that all the time, or is that a running joke inside the court?
He's never really pointed that out.
Okay.
That I know of.
Okay. Matt will confirm that for me. Second profound thing. At bottom, success turns on our ability to conquer pride with virtue. Would you unpack that?
Yes. So I think that if we are going to be successful in our relationships, if we are going to be successful, for me, serving our country or being a mom or being a wife and just making the world a better place generally, I think we have to conquer pride, because putting ourselves first or becoming self-absorbed is basically kind of the root of everything that goes wrong in relationships and thwarts our ability and distorts our ability to serve well. And I think the only way to conquer that, to care less in my job, one of the things I have to work very hard not to care about, and which is one reason why I can't answer immediately who covers the court well, because I try not to read anything about myself, good or bad, is to care too much what other people think, because then that becomes your driving force. And for a judge, that's the last thing you should be concerned about, because it's your job to make decisions based on the law and not trying to enhance your reputation.
Well said. A tremendously deflating thing that you wrote. Sometimes I also read amicus briefs. Now, there are millions of people who work hard on amicus briefs over the years, and there are entire public interest law firms. You and I both used to lecture to the Blackstone Fellows. I don't do it anymore. You can't do it anymore. And ADF is always doing an amicus brief, ACLU, but only sometimes. I mean, like, how often does someone? Is it covered with dust and piles?
Well, no, we get many, many amicus briefs, and some are very valuable, and I do read those. My law clerks read all of them, and then the law clerks, you know, if we have 40 amicus briefs filed, and then we have all the principal briefs in the case, many of them are filed, and they just make policy arguments rather than legal arguments, or they rehash the arguments that have already been made in the principal briefs. So the ones that are really good, you know, if Hugh Hewitt wrote an amicus brief, I am confident that it would be adding something to the conversation and I would read it. So any that bring new information in and actually make legal arguments as opposed to policy arguments, the law clerks pass on to me. They just weed out the ones that aren't adding much value.
Just as this morning, I was driving up here and my Uber driver asked me why, and I started to talk to her, and she was a mother of 5 with an abusive husband who took her 5 kids and fled states and raised them on her own and made a life for herself. And she's back here. She was a mother at 14, and her daughter was a mother at 15, so it's been a difficult life. Judge Thapar made an effort to get to the litigants beneath those piles of brief. Do you as well? I mean, he made a point of saying these are real people whose real lives are involved here. Do you do the same thing?
I do think about the real people that are involved. I mean, that was especially true at the 7th Circuit because of the volume of cases that we saw, and the individuals were very much front and center. In the court, you know, sometimes people ask me, what's the most important case that you've worked on, or what's the most difficult case that you've worked on? And I always decline to answer that question, because every case is the most important case and the most difficult case to the litigants who are involved, because all of our cases involve real people. I tell the story in the book. We announce our opinions from the bench, which means once the opinion is handed down and we come to the bench, the justice who has authored the majority gives just a summary of it to those who are sitting in the courtroom. And the first time that I delivered one of those bench statements, it was a case about veterans' benefits, and it was a unanimous opinion. It was pretty cut and dry, but the Supreme Court bar section was filled with men and women who were serving in the armed forces because they were there for bar admissions that day. And that was a great reminder to me of how these opinions affect real people, because I had to announce a decision that decided against the veteran in the case, full of these, in a courtroom full of these men and women who were serving in the armed forces. And it was, I say in the book, it was a little bit, I had to discipline myself to keep eye contact with them, because while I was confident that the decision reflected what the law required, you know, it still was going to be a great disappointment to the veteran who lost the case.
Justice, I'd like to use our last 10 minutes to talk about writing opinions. Dean Patton is well ahead of the field on AI. We are so all over large language models because of Dean Patton. Has AI made it into your chambers yet, and do you warn your clerks about using it or encourage them to do so?
It's so interesting. As I've been doing some talks in this book, the AI question it's on everyone's mind, because AI is just permeating every aspect of our lives. No, the Supreme Court is very cautious about technology, and of course the large language models are not secure, so there's no room right now, and it would be a big breach of confidentiality at the court for people to use it for opinion drafting, or for law clerks to use it even in drafting the memoranda that they give me, the bench memos that they give me for case preparation. I will say that on personal matters, it's in my chambers because it's all my clerks use now. Nobody Googled, 7 or 8 others who are joining you in this majority opinion. You have to make sure that it's an opinion people will agree to. You know, when I was a law professor and I was writing law review articles, I was writing only for myself, so I could say whatever I wanted and I could lay out the argument the way that I wanted to. But when you're writing for a bunch of other people, it's kind of like herding cats, maybe a little bit more like being a law school dean. You're herding a bunch of people who are very independent, who have their own way of seeing the case. So you have to be able to walk a line and make an argument that's one that at least 5 and maybe more people who have maybe slightly different takes on the case are willing to sign on to. So if you are adamant that you only see the case one way and you're not willing to choose a different path of decision, then you may well lose your majority, and you might have someone jump off the opinion and say, I'm not willing to join your opinion. And if it was a slim majority, let's say it was a 5-4 case, and someone jumps off, then you're left with an opinion that lacks 5 votes.
You just mentioned when you were writing scholarly articles. I didn't have this in my outline. When you did that, did you have in the back of your mind, I might someday want to be on the federal bench and my scholarship should not attract negative attention? Because you didn't live that in Case Western lecture. There are other things that you actually opened yourself up to some criticism that came out in confirmation. Was it a burden on your scholarship that you might end up on the bench?
No, I did not, as Hugh was saying. I mean, nothing about my life choices reflects someone who was trying to construct a record that wouldn't attract attention if one were ever a nominee for the federal bench. It wasn't something that I had any particular ambition or was striving for, or that I ever thought would happen. Justice O'Connor described a Supreme Court appointment as like lightning striking because it's so unlikely. And I think that's true, really, of a Court of Appeals appointment as well. I mean, it depends on so many factors and stars aligning that even if I had wanted to or envisioned that for myself, I don't think it's prudent for anybody to live life that way because it's so unlikely that it would actually happen.
Vice President Pence has been in that chair with me a number of times, and I've also asked Vice President Vance about this. Vice President Pence said he always had the penultimate interview before making a confidential recommendation, and his last question was always, if you're not the nominee, who would you pick? Do you remember that happening? And if so, can you tell us who you suggested you would pick?
I don't remember.
Okay, that's okay, because it's like 20 interviews, isn't it?
Yeah.
It goes on all day long. All right, penultimate question for me.
Okay.
The opinion won't write that you are more Hemingway than Dostoevsky, I like. I think judges could do a lot of that, but what does it mean that the opinion wouldn't write?
So that doesn't refer to writer's block. Judges will say the opinion wouldn't write. And I think this is actually a good expression for people who are not judges to be aware of, because it shows how, when they are writing opinions and deciding cases, judges are really focused on legal analysis. The opinion won't write means I thought that this was how the case should be decided. I thought that this was the analytical path and this was the right way to read the cases that control or the statutes that control, what have you. But when I actually sat down to write out the argument, I realized I can't quite write it up that way because the argument doesn't hold. And so I have to try to write it a different way. I have to try to shift. And that doesn't necessarily mean reaching a different result. That can just mean reaching the same result by a different path, or altering your arguments. But it's because the legal analysis matters to a judge. It's not a question of starting with the outcome and reasoning your way backwards.
My very last question, Justice, page 95. Courts look for the best case in which to resolve an issue. It makes sense when there are splits among the circuits, but how do you actually do that with 4,000 cert petitions? And do you begin the term with like a faculty retreat or a court retreat that we gotta get to Smith someday? I mean, do you ever?
No, we don't do that. We just meet and we discuss the cert petitions on the regular calendar. And we look in those cert petitions. We decide about 60 cases, between like 55, 60 cases a year. And as Hugh said, we get about 4,000 petitions. We choose those cases that require us to weigh in, either because lower courts have disagreed or just because it's an issue of national importance, so it's one that the Supreme Court really needs to decide, but we don't have those agenda-setting conversations.
And this is not a book specific to listening to the law. As you've engaged with members of the public and the media about the book, are they informed about the law, or are Americans still somewhat in the dark about how the court works?
I think Americans are somewhat in the dark about how the court works, which is really my motivation for writing this book, because I want people to understand how the court works, because I want people to have confidence in the institution. I want people to understand that we're not just one of the political branches, that this is very much a legal process driven by legal analysis. We don't always get it right, and people may disagree with the decision, but I want people to be able to criticize our decisions or agree with our decisions on the terms by which those decisions are made, which is the law.
I want to thank you, Justice Barrett, for coming. I want to make sure we get you to the book signing. To be continued.